very busy day of back and forths yesterday, ultimately leading to the Senate Judiciary Committee postponing the scheduled vote to advance the nomination of Todd Blanche as U.S. Attorney General. Came after two Republicans on the panel said they were not ready to support him yet. The decision to delay the committee vote, which had been set for today, comes after Senators John Cornyn and Thom Tillis demanded Blanche and the DOJ put in writing a commitment never to pursue the controversial settlement of President Trump's lawsuit against the IRS. As acting attorney general, Blanche oversaw that settlement, which created a now canceled, he says, nearly $1.8 billion fund that could have benefited Trump's allies, as well as blocked the IRS from auditing or taking other enforcement actions related to tax returns filed by Trump, his family, or his business entities. Cornyn said it offered immunity unavailable to any other American taxpayer. Blanche has said the fund has been eliminated, but declined to formally commit to that in writing. With Republicans holding a narrow majority on the committee, a single GOP vote could block his nomination. It's there where I want to start with MS Now senior legal reporter Lisa Rubin. Lisa, you and I were following this back and forth yesterday, wondering, OK, are they going to do the vote today or not? It sounds like they're not, even though what I see in what these senators are saying is we want to get to yes. DOJ, Todd Blanche, please help us get there. And so what is the thing that they are asking for here that would actually get them to yes?
I think, Ellie, they're asking for some sort of commitment in writing or a legislative fix to the anti-weaponization fund and that breadth of that tax immunity that Todd Blanche issued to the president, not necessarily through the settlement itself, but through this addendum or memorandum that he signed as the attorney general. I'm not sure that the senators are particularly fixated on how they get there, whether it's some form of amendment to the settlement agreement itself or a rescinding of that memo by Todd Blanche and some other commitment. Maybe it's even a piece of legislation that prevents Congress from appropriating funds for anything aligned with or akin to that anti-weaponization fund. But whatever the solution is, you heard it from Senator Cornyn himself. The Department of Justice doesn't seem to have been as cooperative with him in working toward that fix as he would want them to be. And you and I both well know hell hath no scrutiny like a senator scorned. And John Cornyn, having been primaried out by Ken Paxton with the support of the president, isn't particularly in a mood to grant him any favors right now.
The way that I've been thinking about the Cornyns and the Tillises, sometimes the Bill Cassidys, the folks who are not coming back to Congress for whatever Trump-influenced reason, is that, yes, they might be more willing to speak out against the party, create hay in moments like this, but ultimately they are still Republicans. And so I think we've seen up to this point these people vote that way. This is, I think, the first true moment of watching a tangible impact of their dissonance or disagreements with the administration actually manifest, in this case, in a postponement, but we'll see ultimately where the votes fall. I think the 1776 fund is one piece of it, and the AG has repeatedly tried to say it's moot, it's moot. My understanding now, if you listen to Cornyn and Tillis, is that they are actually more focused on the IRS tax piece of this, the one that would allow the president basically to be easy breezy with the IRS for the rest of his life, as well as his sons and his companies. What is the fix to that? Because that feels a little bit more difficult than just saying the 1776 fund is dead and I promise we'll never let people apply for funds out of it.
You know, what's so funny about that is that's the easier thing to fix because that is the immunity that has been granted to him, again, from this side memoranda, a one-page agreement. It's not even an agreement because it's not countersigned, a one-page memo from the acting attorney general. The breadth of that, the scope of that agreement, Todd Blanche has been insistent that it's within his powers as the attorney general to sign that. There are some folks who question legally whether he could have done that because it was not a matter that was referred to the Department of Justice for their enforcement. In any event, that's something that Todd Blanche uniquely has the power to fix. Why it is that his Department of Justice right now isn't able to fix that to the senator's satisfaction is really one of the big question marks looming over my head.
Looming over, and yet I think there is an explanation of the man in the Oval Office might highly disagree, and this has always been the box that Blanche has been in. In order to get the job, he's going to need to make assurances to people who will give him that job, the senators, that could then alienate him with the person who put him in that job in the first place, the president. There's another big story yesterday from the Hill that I want to get you on. Dr. Anthony Fauci invoked the Fifth Amendment more than 100 times during a Senate hearing on the COVID-19 pandemic. He was subpoenaed to testify by Republican Senator Rand Paul, who has had a years-long feud with Fauci. which the doctor addressed in his opening statement.
The only conclusion I can reach is that the sole reason he is calling me before this committee is to get me to say something, anything, that could vindicate his repeated public pledges that I end up, in his words, quote, behind bars.
The questions are very pertinent to your decision-making as head of NIAID, as well as a chief advisor to the president. Do you still refuse to answer the questions?
On the advice of counsel, I respectfully decline to answer based upon my rights under the Fifth Amendment of the Constitution. Decline to answer, decline to answer, decline to answer.
The committee will have to consider, after this hearing, what appropriate action should be taken against you for the failure to testify after being directed to do so. It's against the law to obstruct an investigation of Congress. There will be repercussions to your refusal to testify today.
Lisa, I think people see Dr. Anthony Fauci. First, they question, what year am I in? But second, they say, why is there a legal reporter talking to me about a public health official's testimony? And that's because this wasn't really a hearing about public health. There were a lot of potential legal ramifications looming over it, including the idea that some of these senators were saying the P word, perjury. Can you talk about the strategy of pleading the fifth and if it was the right one in your estimation?
You know, look, Allie, I don't practice law anymore, but as a former lawyer and someone who sometimes worked with criminal defendants or people caught up in investigations, I do think it was a legally smart thing to do. Rand Paul has made no secret of his desire to see Anthony Fauci held criminally liable for the actions that he took during the COVID-19 crisis. And let me just introduce a couple of variables that make it a smart thing to do. First of all, the pardon that he was given by President Biden on January 19th of 2025 only relates to his conduct as a public health official, but looking backwards. And so anything that he says or does from that point forward is fair game for criminal prosecution, including possibly lying to Congress. There's also the possibility of state investigations or prosecutions, as our colleague Jordan Rubin explored in a column yesterday. You and I both know that federal pardons have nothing to do with what states can do. That's what allowed a number of states to go after President Trump and others in his circle with respect to the 2020 federal election interference issues. And then there's the final question about the validity of that pardon at all. This is the one that I think is legally on the shakiest ground, but you and I both know that the president himself and others in his circle have repeatedly emphasized their belief that the pardon that Joe Biden gave to Anthony Fauci and others isn't valid, both because of their perception of President Biden's mental state, as well as the fact that he used what's called an auto pen and didn't sign it by his own hand, but that a machine did it on his behalf.
Which other presidents, including President Trump, have done over their tenures. We're going to keep watching that thread on the Hill. You don't practice law anymore because you do such great reporting for us here at MS Now, and you have a new report out that reveals Secret Service agents were pressured to covertly surveil former FBI Director James Comey. The request came after Comey posted this Instagram photo last year, seashells arranged to read 8647. President Trump and his allies claimed the post was a threat on the president's life. Of course, Comey has denied that. Internal documents made public through court filings from Comey's legal team revealed the Secret Service, quote, knowingly conducted illegal electronic surveillance of Comey at the request of a high-level DOJ official. MS Now has learned some Secret Service agents were concerned about that request to secretly access Comey's phone and monitor him, arguing they didn't have the legal authority to track his phone without a warrant. Records show a top DOJ official had agents track Comey despite those reservations. In a statement to MS Now, a spokesperson for the Secret Service declined to comment, writing, quote, we have great respect for the judicial process because this matter is currently pending before a federal court. Any comments will be made through our official court filings. The new documents, though, were released as part of Comey's push to have the federal indictment against him dismissed. Talk to us more about this, because on its face, it doesn't sound like they had what they needed to do this kind of surveillance.
No, they didn't have what they needed to do this surveillance. So instead of going out to get a search warrant from a court, what they did was apply to Verizon, which was Jim Comey's phone service provider, for what's called an exigency exception that allowed them to literally ping his cell phone as he and his wife Patrice were driving back from North Carolina, where they saw that shell formation, to the Washington, D.C. area. When they went to Verizon, they had to sign a certification saying that This was the kind of emergency that put somebody's life or limb at risk. And yet, the internal documents that we've seen that Jim Comey attached to his motion show that was very much in doubt within the Secret Service, that there was an agent who memorialized calls that he had with other people where he and others advised that this was legally questionable. It was legally a bad idea. Our reporting and our sources at the Secret Service, and this is reporting I did with our colleagues Carol Leonnig and Fallon Gallagher, illustrate that the concerns that we see on paper attached to Comey's filings were, if those were at a 4 on paper, they were at a 10 within the agency, with people really, really struggling to understand why they would accommodate the president's wish to investigate Jim Comey and that directive from what somebody says on paper was the number 3 guy at the Department of Justice. We don't know who they were referring to. The number 3 guy at DOJ is usually the Associate Attorney General. That's a civil position. So again, we don't know who they were referring to, but it was the perception of those within the Secret Service. They were being told, despite your misgivings, you go out, you do this, don't go to a court, don't pass go, you go straight to Verizon, you tell them this is an emergency. And that's what led to Jim Comey's phone literally being pinged as he drives back up the coast, back to his home in Washington, to have a voluntary interview with the Secret Service.
Yeah, we have so many more questions now in light of this reporting and the documents that Comey's team is filing. MS Now senior legal reporter Lisa Rubin catching us up to date, at least on this latest chapter. Thank you.